I'm excited to be here this afternoon to talk about IP and patents in general, because for me, IP is bread and butter, and I'm passionate about IP, and I'm also excited by the various speakers who have gone before me, and I'll take on the PS, Dr. Bitange Ndemo, on the invention that he's coming up with, and I'll tell him that at KIPI we can be able to provide the search to provide for him the prior art so that he does not have to reinvent the wheel. And maybe before I go on, just to make one clarification on, there was a question that was asked about the difference between what is protected by copyright and what is protected by patents. And since Maricela is here, maybe she'll be able to give more on copyright. But maybe I'll clarify by giving an example of, if you write a book, perhaps describing how to make a computer, the book itself is protected by copyright. So that what you have is to prevent other people from copying your book. But if you read the book and you make the computer, the copyright does not extend to that you can be able, any other person can be able to read your book and make a computer. So the function, part of it is what protected by the patent. So that the computer itself, that will be protected by patent. And with that, I want to embark on my presentation this afternoon. And we'll be looking at the patenting requirement. And for me, the starting point is to look at the patent system. The objective is to promote technological and economic development by encouraging innovation. And for us in Kenya, that objective is enshrined in the Industrial Property Act of 2001, which is an act of parliament to provide for promotion of inventive and innovative activities through the grant of patents, utility, molders, and industrial design. And in order to do that, the law also provides a balance and checks, in that, as the MD had said, that IP rights are private rights. So there's also need to look at the public interest, and the law itself has provision for that. It's a balance of the rights, the private and the public rights. And in the patent system also provides for those sort of mechanism. And as the various speakers have said, the Industrial Property Act does not exclude computer programs and software from patent protection. And a comparison was made between the repeal, KIPI 509, and the present act, which expressly excluded computer programs from protection. And therefore, under the current law, the software inventions will be treated as any other inventions. And that's what we are going to look at, how the applications, patent applications are treated at KIPI, or what does the law provide currently in as far as protection of inventions is concerned. And the starting point is what is a patent, to define what exactly is a patent. And Dr. Isaac talked about the same thing. It's a grant of exclusive rights for a limited period of time over specific subject matter. And that subject matter or the invention has to constitute a particular type of advance in return for disclosure of the advance or the invention to the public. So that's the bargain, that you get this exclusive right. In Kenya, it's for 20 years. And you have to really say, what is it that you have invented? You have to state your invention. As we'll see later on, there are requirements for the disclosure. You have to disclose your invention fully, or the advance that you're bringing to the public. You have to describe that. You have to disclose that in order for you to get the protection for the 20-year period. And the key thing this afternoon is about the invention. Patents deal with inventions. So really, it's very, very key for you to be able to identify what is your invention, and does your invention fall within what is provided in the law. And once you get those exclusive rights, you have control, because in essence, you're getting a monopoly for the period of the 20-year period that you are given. You're able to control who makes, uses, or sells your invention. And the law provides that you can seek injunction against infringement, and you can also claim damages for infringement from the third party or any other person that is not authorized by you to exploit your invention. And the law provides for this mechanism, as has been said, that it's rigorous exercise in obtaining a patent. The reason being that you have to meet the requirements of the law. And the other thing is concerning the monopoly that you get. So it has to be really an invention that you have come up with, that you are saying, this is what I've invented, I need protection in order to exploit my invention and recoup the investment and the time that I've used to come up with the invention, so that after the patent expires, any other person can be able to exploit. And there are various requirements given by the law in order for you to get or to obtain a patent. One of it is about the patentable subject matter, that your invention has to fit within what the law describes as patentable subject matter. Again, your invention must not be excluded by the law. And the third one requirement is the disclosure requirement. You have to disclose what your invention is, such that people in the same field can be able to work out that invention or to reproduce your invention by reading the description of the invention. Then the last one is the patentability criteria, that your invention has to be new, it has to have an inventive step, it has to be industrially applicable. And we look at these requirements in detail. And the starting point is the invention. And for me, that's the key thing. The invention is the key thing, because that is what is protected by a patent. And the question I normally ask many people is, what have you invented? What is your invention? And the law defines an invention as a solution to a specific problem in the field of technology. And that invention must be with respect to either a product or a process. A product, it could be a machine. In ICT, it could be a keyboard or a mouse, or a process or method. The same thing. And the method or process is a sequence of steps that complete a task or accomplish a result. So those are the two categories of invention that you can be able to apply for to get a patent. Ideas are not patentable. Yeah? The second point to note is that business methods are not patentable under the Kenyan law. There are countries which allow patenting of business methods. For example, the US, they don't have restriction, as Dr. Isaac said previously, they don't have that restriction, but in Kenya, there's that restriction of the business method. They are not patentable. The other things that are also excluded from patent protection, discoveries. If you discover something that was already existing, you can't get a patent for that. Scientific theories, mathematical methods, you cannot obtain a patent for that. A discovery, for example, why a giraffe has a long neck yet does not faint. If you discover the reason, you can't get a patent for that. Or E is equal to MC squared. The scientific theory or formulas, you cannot get a patent, you cannot apply and get a patent for that. They are not patentable. The law excludes them from patent protection. The schemes, rules, and methods of doing business, as I said, they are excluded from patent protection. However, some countries do allow. The US Australia and many other countries allow methods of doing business. I get a lot of questions from applicants asking why business methods are patentable in other countries and not in Kenya. The reason is that the Kenyan law does not allow patenting of business method. Performing purely mental acts, also you can't get a patent for that, or methods and rules of playing games. However, if you come up with a board for playing games, you could get a patent, but not the rule of playing the game. Another category that is excluded from patent protection are methods of treatment of humans and animals by surgery or therapy. They're also excluded from patent protection. However, the products are patentable. The pharmaceutical product, the drugs, you can obtain a patent for them, but not the method of treatment. Just to clarify, when you're talking about the ideas and invention, just like I said, ideas are not patentable. However, if you reduce the idea to practice, it may be a patentable invention. Then you are subjected to the patentability criteria. And an example is the M-Pesa, the Zap, and Ucash. All these are money transfer services. The idea behind them is to transfer money using a mobile phone. So that's the idea. You can't get a patent for that idea, where you exclude everybody else from transferring money using a mobile phone, coming up with a mechanism for doing that. What falls into the patentable subject matter is the invention. How do you do it? How do you accomplish that idea? That's what could be fall under the patentable subject matter. And remember, like we say, the invention has to relate either to a product or a process. Yeah, so if you come up with a device that you're able to do that, or a process of doing that, that could fall into a patentable subject matter. Other examples that we've had in the past are people claiming they have come up with the idea of paying rent using a mobile phone, and they would want exclusive rights. They would want to obtain patents for that, or paying insurance premium using a mobile phone. That's the idea. And it's the same thing that you can't patent the idea. You got to come and say, this is what I've invented. This is the way you can be able to pay the rent using a mobile phone. What is the method that you have invented? So that becomes patentable. But now the idea, of doing the financial transaction. Another idea of advertising on a hot air balloon. I want to prevent other people from advertising on a hot air balloon. I want those exclusive rights. Or advertising on a road service, so that nobody else will be able to advertise on a road service, or advertising on the inside cover of an exercise book. And the reason is that nobody is doing it in Kenya. And so I don't want that when I start advertising on a hot air balloon, other people to come and start doing the same, copying my idea. And again, it's the same thing. How do you do that? That is what can fall under the patentable subject matter. So need to be very clear. This is a lot of issues to do with the ICT, people coming up around the M-Pesa thing, the mobile phone, things they're able to do with the mobile phone. A lot of questions in this area, a lot of ideas being generated. And these are the sort of things that we, people want to protection for. The second criterion is the disclosure requirement. The law provides that you must disclose your invention. And this is if your invention falls under the patentable subject matter, you make an application at KIPI or in any patent office for that matter. There's a disclosure requirement that you must disclose your invention in detail and in full terms to enable a person of ordinary skills or person skilled in the art to make and to evaluate your invention. In other words, when you apply for a patent, we don't check the product you have made. We don't check whether it's a computer we made. We don't ask you to give us a sample of the computer. We'd want a written description of your invention. And that description must be full to the extent that any other person in the same field will be able to reproduce that invention. And that fits in with the basis of the patent system, is that you're getting that protection in return for full disclosure of the invention, such that when your rights expire, other people can be able to work out your invention by reading your patent document. The other thing is also to allow other people to improve on your invention, because you say, at this point in time, this is what I've invented. This is the extent of my invention. And other people can be able to take on from there and improve on that invention. And it's also possible they could also patent the improvement they have come up with. And you'll note that insufficiency of disclosure is a ground for invalidating the patent. If the disclosure is not sufficient to enable a person in the art to make that invention, somebody could apply for that patent to be invalidated. Another category, as Dr. Isaac projected you on the screen, are the claims. Very, very important part of your patent document. That's the legal part. That's where the lawyers spend a lot of time discussing the breadth and width of the invention, the scope of the invention. For the claims, define the matter for which protection is sought. And it's a requirement that the claims must be clear and concise. One, to demarcate the extent of your protection, of your invention, such that people can do not infringe. They must know the extent of your protection in order to avoid infringing on your patent. And the claims must also be fully supported by your description. Yes, you described the invention, but you may claim more than you have described. Very, very common. I get applicants coming and say, I don't want to disclose a lot so that other people cannot work out my invention. But I want to claim much more than what I've disclosed. Again, the law requires that you fully disclose your invention, and whatever you put forth as your claims must be supported by the description. And the claims must also be set in terms of technical features that define that for which protection is sought. Must be in terms of the technical features. If you describe a computer, you must identify what are the features of this, of the computer. In ICT, one of the issues is, in terms of the claims, what do you put forth as your claims? A computer program form. And the question would be, what would the technical features in the computer program? But these are the issues that arise in the field of ICT. They are really very technical. The extent to which the computer program or software can be protected. It's a debate not only here in Kenya, but worldwide. Even in countries like US, where they don't have restriction on what you can patent, the software or the business method, they are still also debating the extent to which you can be able to protect the software and computer programs. And once you go through all this procedure, does it meet the subject matter? Does it fall within the patentable subject matter? Have you disclosed enough? Have you put forth the claims? You'll make an application at KIPI, and at KIPI, we subject that application to the criteria, and there are three. We have to check whether your invention is new. We'll have to check whether your invention has an inventive step, and lastly, we have to check whether your invention is industrially applicable. And we look at them in detail. I start with the last one, the industrial applicability, because it's a much simpler one to check. And that requirement is met if the invention can be used in any type of industry. So long as the invention has some useful purpose it will be able to meet the industrial applicability test. The first requirement is the novelty or the newness, that your invention must be new. And your invention must meet the three criteria. All of them must be met before you obtain a patent. And novelty is checked against the prior art. And the question is, what is prior art? Again, the law provides that everything made available to the public anywhere in the world before the filing date. So the filing date is very critical, it's very important, because that's the starting point. We'll check for any material that was available to the public before the filing date. In terms of publication, was there a prior publication disclosing your invention? Or did you make a presentation at a conference? And especially in a university environment, that could be very critical. If you make a presentation, you will be sort of invalidating your own patent. Or was the invention used in public? So we check for all the documents that could have been, or information that was available to the public anywhere in the world, not only in Kenya. A lot of times I get applicants saying, my invention is not being used in Kenya, or is not being done in Kenya, but I know it's being used in other countries. And the answer is that you can't borrow an invention from outside and you patent in Kenya. But if it's not patented in Kenya, you could go ahead and maybe commercialize it, but you can't patent. Again, it comes back to the question of the whole patent system. It has to be your own creation. It has to be your own invention that you patent. You cannot patent somebody else's invention. It has to be your own. You can't take somebody that is existing in the public in other countries and you patent it or protect it in Kenya. That is not allowed. The second criteria that we subject the application is the inventive step requirement. And the inventive step is checked against a person skilled in the art to which the invention pertains. And again, the critical point is the filing date. We have to look at the prior art, what was available to a person skilled in the art, and even the common knowledge in that particular field. Consider, a person skilled in ICT. So if the invention relates to ICT, who would be the person skilled in the art? It could be a software developer. But again, it goes with the prior art that is available at the point the application is being examined. Yeah, so these are some of the considerations that we put forth. The person skilled in the art. We also look at the problem being solved by the invention. What are you solving? What the problem are you solving by your invention? And the question we would ask is, would the person skilled in the art arrive at the same solution by routine steps? So if you have come up with a software for doing something, you're a software developer, the question is, we look at the invention as enshrined in the claims and ask, would a person skilled in the art be able to arrive at the same solution, by routine steps? Not being inventive, just doing their job. Given the problem, can any other software developer be able to come up with the same solution? And as I conclude, just to look at some example here, in addition to what Dr. Isaac had given, example of what you encounter in the software applications, patent applications. For example, this is a cross-border or intercurrency transaction system. Yeah, I know this invention or this inventor wants protection for is a situation where you can be able to transact or transfer money from one country to the other through the banks. You have one bank, for example, in Kenya, another bank in Uganda. You want to transfer money to Uganda, you can be able to do that transaction. And these are sort of things that are very, very common in ICT field. And if you look at, what we look at first, does it meet the patentable subject matter criteria? Is a system. So at the face value, it may meet that requirement. It could falling within the definition, for example, of invention, a product or a process. This would fall in the category of a system. But then we go and look at the excluded subject matter. Remember the discovery, the mathematical formula, the business method. Is it excluded by law? And for me, this would fall in the business method category. So it's possible to reject this sort of a patent application based on it's a business method application, because all it's being done is to transact. One is transacting money across the border, and also from one currency to the other. Yeah. So at that point, it could be rejected that it's a business method. The other point at which it also could be objected to is the newness. Yeah, is it new? And for me, I would look at the prior art to be like the Western Union. Yeah, they do the same. If you transfer money from Kenya to another country, they receive money in their currency. You send in Kenya shilling, they receive it in their currency. So there's a lot of issues here to be looked at as regards to ICT. There are issues that that are coming up that needs to be debated and thrashed out. And I'm happy for this kind of a forum. And example number two, again, as Dr. Isaac will tell you, patent agents have developed their skills of overcoming some of these objections. And one of it is to rearrange the claims. Sort of, if you object to the business method, they introduce a device. Yeah, it's a device, not a business transaction. And this is a classic example of that, where somebody is claiming an apparatus for teaching items to a user, comprising, and you look at the items in bold, comprising memory means for storing a file of said items, display means for presenting each item to said user, you have input means, and processor means. Those means are not in the claims. They fall in the description. They'll disclose what their memory means is. But even then, if you look at the sort of things that have been elaborated here is a memory means, display means. A memory is in a computer. Will have a memory. The display means could be the monitor. Input means could be your keyboard. Processor is a computer has a processor. And you look at the sort of the scope of what this person is claiming is a system for performance evaluation. The sort of things you have, you can use a system to rank your students in class if you look at it critically. So, and for me, that would be sort of, you're processing data. Yeah, really, it's a processing data, and becomes very critical because, again, it could fall under the business method category. You could be rejected on the novelty. Could also be rejected on inventive step, because really the apparatus being defined here is sort of going around the objection that this method is a business method. But when you look at it critically, these are common items you find in a computer. And as I conclude, sort of is a signal, the one you find in your mobile phone. Looking at the strength of the network that you are receiving, and even in terms of the software patent application or inventions, the strength reduces from the hardware to the software. The hardware, if your invention relates to a hardware, the patentability increases. As you go down maybe to hardware controlled by software, a good example would be the washing machine. Well, it's possible, though the patentability is reduced to than when it's a hardware alone. And if you go down the chain, you have a computer program recorded on a carrier, e.g., a machine-readable medium, a CD-ROM. Again, these are skills that are employed by the patent agents to overcome some of these objections. But still, even if they try to overcome that, you got to ask the question, again, what is the invention? Because for me, that is very, very key. You got to say, what is the invention? Is a computer program recorded on a carrier? Is that the invention? Or is it the CD-ROM? Is it the memory? And what is new in it? What is new in your memory? Is it the program that you have loaded in your memory? What makes the memory that you are claiming to be new or to be patentable? Then the last category are the software of data processing. So those ones are very, very tricky. They are down there in the full chain. And there are many other issues in software. For example, enforcement raises other issues there. Very, very tricky. How do you enforce your rights in case you get the patents? Maybe Dr. Heiser will talk about the situation in US where you have these people called the patent trolls. These are guys who maybe patented certain, made patent applications for even the internet many years ago. And then when the internet is on, they start asserting their patent. Yet they've never done anything. They are not producing anything. They just have a big office and sending all these letters to the people who are in business, threatening with patent infringement. And they get some good money. So there are all these issues that surround ICT field, the software business, and enforcement, online infringement. There are issues that are there that maybe today and tomorrow we'll be able to discuss them and maybe come with a way forward. And I want to end at this point and then say thank you.